Estate planning is not always just about what happens to you after you've died, after you've passed away. The most important part of estate planning is what happens to you during your lifetime. If you were to become incapacitated right now, what do you have in place to take care of you now? All the documents that we're going to talk about today, all of them go into your estate plan. Revocable trust. A revocable trust is the foundation of your estate plan because it says what needs to happen during your incapacitation and what happens after you have died. If we put a revocable trust up against a last will and testament, there are several advantages to the revocable trust. A trust maintains your confidentiality. When you have a revocable trust, the information in that trust is confidential. It's your information. The only people that are really entitled to see it are your trustees, your successor trustees, and your beneficiaries. And even your beneficiaries, there's some argument that they are really only entitled to see the sections of the trust that actually pertain or that are relevant to them. A revocable trust maintains your confidentiality. This is the complete opposite of a probate. If you have a last will and testament or you do not have a last will and testament at all, your estate will have to go through the probate process. Everything that is in the probate down at the courthouse is usually always public record. So anyone who wants to just go down to the courthouse, attend hearings, and hear and see what is going on in your probate can do that. Now, you're not living anymore, and I've had some people say they don't care what happens after they die. However, the heirs might, your beneficiaries. Their names and addresses are usually always part of that open record that anyone can look at. Going back to the trust, a revocable trust also gives directions on what happens if you become mentally or physically incapacitated. And it will work in conjunction with your power of attorney, your financial power of attorney, and your healthcare power of attorney. The revocable trust allows and gives directions to what you want to happen if you were to become incapacitated. And because you have funded everything correctly and everything is in the name of your trust, your successor trustee can simply step in your shoes and take control of all your assets for your benefit. Your successor trustee has a fiduciary duty to take care of you. If you become incapacitated without a plan in place that states what you want to happen, then your loved ones will have to go down to the courthouse and most likely get a guardianship. A guardianship is basically, I call it a living probate, except I think it's worse because you are still living and your family is fighting over what happens to you while you are alive. And that is why it's so important to understand that estate planning takes care of you during your lifetime. With proper funding and proper trust funding, your revocable trust will work hopefully exactly like you intended it to do. But if you have assets out of your trust, then your trustee does not have control over them. And that is why it's so important to have your trust as the foundation of your trust, because if you've also done a power of attorney as part of your revocable living trust centered estate plan, then that power of attorney, while you are still alive, can go out and change the title of an asset that is not in your trust and put it into your trust for them to then have control over it under the terms of the trust. Now, that is in stark difference. If you had no estate planning whatsoever, your family would again have to go down and get a guardianship to take care of those assets for your benefit, because there is no direction by you on what you want to happen with those assets. What we are talking about here could be bank accounts, financial accounts. It could be commercial real estate that you own, rental houses, your own house, maybe a side business, whatever it is. It is really important because a revocable trust will give direction to your successor trustee on how to take care of those assets and what to do with them so that you are taken care of exactly, like I said, how you want to be taken care of. A revocable living trust in one state is usually the same as a revocable living trust in another state. A revocable trust in Texas will usually work the same as, say, in New Mexico. There are some exceptions with specific types of trusts that have to do with tax savings, but for 99% of the United States, a revocable trust in one state is going to be very similar to a revocable trust in any other state, and it will work fine. And what's nice about it is that in most jurisdictions, a trust from one state will be recognized in another state. In general, a revocable living trust made in one state is going to be good in another state. And you've heard me say before, you need to be reevaluating your estate plan on an annual basis. If you move to another state or you move to another jurisdiction, then you might revisit whether or not that revocable trust needs to be restated for specific laws that are in your new state of residence. Keep your trust up to date and you should be okay. Pour over last will and testament basically means that if you have a revocable living trust centered estate plan, your pour over will and last will and testament is there just in case you forget to put an asset into your trust. So let me give you an example that we see on a regular basis. A couple will come into our office, husband and wife or life partners, and we will do a revocable living trust centered estate plan for them. As part of that process, we make certain that the house that they're living in is put into the name of the trust. In other words, we change the title from Sarah and Tom Gomez to Sarah and Tom Gomez, trustees of the Sarah and Tom Gomez Revocable Living Trust. Got it? As time goes by, though, they sell that house and maybe downsize to a smaller house. Maybe they get a bigger house. And they forget to tell the title company that they have a trust. Or maybe somebody just doesn't catch it. That new property, that smaller house or bigger house, gets put just into their name. And when they die, because it's not in the trust, it's not funded in the trust, it has to go through the probate process. And that defeats one of the main reasons they got a revocable trust in the first place. It is really important to have that pour over will just in case that scenario happens. The pour over last will and testament basically provides that if there are any assets not in the trust when you die, those assets will have to be probated, but they'll be put into the trust, they'll be poured over, so they will be distributed according to the terms of that trust. Going back to Sarah and Tom Gomez, that new house that they purchased will go through the probate process, but it'll be distributed to the Sarah and Tom Gomez Revocable Living Trust. If Sarah and Tom Gomez do not have a pour over will, then that house will be probated under the laws of Intestate Succession, which means the property may not go to who exactly they wanted it to go to. A pour over last will and testament is an essential part of a revocable living trust centered estate plan because it is kind of a backstop. It is a bucket that'll catch those assets that are not in the trust and put them into the trust for distribution according to the terms of the trust. Exactly what you want to happen. Durable power of attorney. A durable power of attorney grants somebody, anybody, the power to be your agent and legally act on your behalf even if you become incapacitated. And that's really important because there are some power of attorneys out there that do not go beyond incapacitation. A durable power of attorney is a financial power of attorney that grants somebody the authority to act legally on your behalf as part of your revocable living trust centered estate plan. This is a crucial document. I talked about a pour over will and last will and testament and how it's kind of a backstop after you die. The problem with having that or having to use that is your estate will have to go through the probate process. What happens though if you are living and you become incapacitated? Let's go back to Sarah and Tom Gomez. Tom is now deceased and Sarah is now incapacitated. Sarah named her daughter Monica as her durable power of attorney, and Monica is also her successor trustee for her trust. As successor trustee, Monica is going to determine or take an inventory of Sarah's assets, and Monica finds a title for that new house that is only in Sarah's name and not in the name of her trust. Because Sarah is still alive, Monica can exercise her power as Sarah's power of attorney and transfer the title from Sarah's personal name to the name of the trust. Why is this so important? It is so important because by giving Monica that power and Monica actually using that power to transfer that new house from Sarah's name to the name of the trust, she has literally saved Sarah's estate thousands of dollars by putting it into the trust now. If Monica did not exercise that power or she did not have that power, then that house would have to go through the probate process. That is why a power of attorney is so important. A durable power of attorney will allow somebody, your agent, to act on your behalf, make certain that all of your assets are truly funded into your trust for distribution under the terms of the trust, exactly how you want things to happen. Healthcare power of attorney. A healthcare power of attorney is very similar to a durable power of attorney, but it only deals with your health. And this is actually an important distinction. The healthcare power of attorney grants somebody who you implicitly trust the power to make decisions on your behalf. That person could have the authority to prevent people from seeing you, physically determine which doctors you should be going to and what medicine you will be taking in conjunction with the doctors. All important decisions and a power that a healthcare power of attorney needs to have. A healthcare power of attorney is going to work in conjunction with your successor trustee as part of your revocable living trust centered estate plan to make certain that you get the proper health care. And let me explain what I mean there. Your healthcare power of attorney needs to work with your successor trustee to utilize money, the funds that are in your trust, for your healthcare. This really creates a good checks and balances for you, and it's another way to make certain that you are taken care of the way you want. You name one person that is in charge of your health, making health decisions, who's making sure you get exactly what you need, and you have your financial person, your successor trustee, who's looking after the money and ensuring that your healthcare power of attorney is spending that money correctly for your needs. That does not mean they should deny you from getting the care that you need, but you also do not want your healthcare power of attorney going off and doing something, or maybe going off some crazy tangents that you didn't really want, or spending money on procedures that are not going to have any effect. We are creating checks and balances. Your successor trustee, your healthcare power of attorney, and maybe even your durable power of attorney, all working together, getting you the health care that you need, getting the services that you need to keep you in your house for as long as possible, if that's what you want. Everything that you have outlined in writing to get you the health care that, well, you want. Living will or advance directive. These two terms can be used interchangeably depending on what state you live in. A living will is a very, very important part of your revocable living trust centered estate plan. This is the document that lets medical professionals, your family, and your healthcare power of attorney know exactly how you want to be cared for if you are in a persistent vegetative state. Those are the key words, persistent vegetative state. What does that mean? That usually means, depending on your jurisdiction, that 2 independent physicians have determined that there is 0 brain activity and there is 0 possibility of that brain activity reigniting. Do you want to continue to get food, water, pain medication? Do you want to be on a machine to help you breathe? All of these decisions are up to you, and they are part of your living will or your advance directive. The living will or advance directive is an extremely important part of your revocable living trust centered estate plan because it gives instructions to the world on exactly what you want to happen. The unintended benefit of this is that it also alleviates the pressure and takes the burden off of the shoulders of your family and the healthcare power of attorney that you have named, because you have stated what you want to happen if you're in a persistent vegetative state. So instead of them having to have sleepless nights trying to decide what to do, what you would think, worrying about it, you have instead made that decision for them. You have said exactly what you want to happen. Just pain medication, just food, a combination of water and pain medication. You have made that decision, not them. All the healthcare power of attorney has to do, all the medical personnel have to do, all the family has to do is follow your wishes. HIPAA authorizations. You guys have seen a version of this every single time you go to the doctor or a hospital or go anywhere to get any type of medical procedure or treatment. Almost all medical personnel want it in writing on who has access to your medical records, who they can talk to, who can they show records to. And it's very important to have a general HIPAA authorization in place as part of your revocable living trust centered estate plan. The HIPAA authorization is usually a general grant of power to all medical personnel to share your medical records with specific people. Usually your healthcare power of attorney is the main person that is to receive that information, but it could also be other family members who you also want to be informed, so they will work with and help your healthcare power of attorney. These are usually tough decisions, so it's best to have one person in charge, but it's also very helpful for that person to have others to lean on at a difficult time. 3 healthcare documents in your revocable living trust are your healthcare power of attorney, your living will, also called an advance directive, and your HIPAA authorization. All of these are part of your revocable living trust centered estate plan to get you the healthcare exactly how you want it. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that, so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.